From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court keeps the Title 42 border expulsion policy in place for now, as new census data shows which states Americans are fleeing and where they're moving instead. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, editorial board member Mene Ukwe-Barua and columnist Kim Strassel. The case is Arizona v. Mayorkas, Alejandro Mayorkas, the Secretary of Homeland Security, and the order from the Supreme Court is a stay that it says precludes giving effect to the district court order setting aside and vacating the Title 42 policy. And the Supreme Court is then directing the clerk to establish a briefing schedule to put this case on the February 2023 argument calendar. That probably means that we will get a decision in maybe June, the end of the Supreme Court's term. But on a pretty narrow question, here it is, the parties are directed to brief and argue the following question: whether the state applicants may intervene to challenge the district court's summary judgment order. And so, Mene, I'm getting a little tangled here on all of the procedural complexities of this litigation around Title 42, and I'm hoping you can clarify that.
Absolutely. And I have to start by saying I appreciate the way you set the table there, because it already was helpful in clearing up, I think, a lot of the misconceptions people might have if they merely saw the headlines yesterday, which basically said the Supreme Court upholds Title 42. Now, that's not quite right. Basically, what happened yesterday was that the Supreme Court ordered that they will hear a case considering the right of several states to intervene as plaintiffs on behalf of Title 42 and potentially to keep the federal government's authority to implement a policy like that in place in the future. So what the district court ruling in November said was that Title 42's implementation was arbitrary and capricious, and basically suggested that the Centers for Disease Control did not have the power to make a sweeping policy that would allow the federal government to quickly expel migrants the way that it has been doing since March of 2020. And so they blocked the policy from ever being implemented. And the Biden administration more or less had already been planning to cancel that policy in the first place. And so they didn't really mount a particularly strong legal defense of it. And so that's what the 19 states, all GOP-led states, said. Basically, the federal government did not properly defend its authority to implement Title 42 in that case. And because they had been making bad faith legal arguments, they argued to the Supreme Court that they should be able to step in and make an actual case for Title 42's broad legal merits. And so that's what the Supreme Court's going to be considering. In the immediate term, basically, the Supreme Court said that the policy can continue to operate in the meantime between now and when they hear the case. So that means that the federal government has reversed its decision to cancel the policy in the near term and is going to continue to quickly expel migrants who come into the U.S. to claim asylum. So the broader decision about the policy's constitutional merits is still hanging in the air. That will be decided later by the Supreme Court. But for now, basically, they said the government can continue to operate it in the meantime as we decide about it.
To underline that, there's a legal analyst that I was reading this morning saying that there are two actual cases about Title 42. There is a Texas case that struck down the Biden administration's attempt to end the policy, saying that it did not follow the Administrative Procedure Act. And then there is this case we're talking about from the District of D.C. Court. And that said that Title 42 didn't have a basis in the first place. And so while both of those rulings were in effect, that one took precedence. But now the Supreme Court has stayed that ruling. And so according to this legal analysis, that puts the ball back with the district court in Texas. And so the upshot of that is that Title 42 is continuing. Here's the statement by the Department of Homeland Security. The Title 42 public health order will remain in effect. Individuals who attempt to enter the United States unlawfully will continue to be expelled to Mexico or their home country. People should not listen to the lies of smugglers who take advantage of vulnerable migrants, putting lives at risk. The border is not open, and we will continue to fully enforce our immigration laws. Notable in the Supreme Court's stay here is two justices who said they would have denied the stay. That was Justice Sonia Sotomayor and Justice Elena Kagan. And then a pretty strong dissent from a unlikely pairing, Justice Neil Gorsuch and the newest Justice, Ketanji Brown Jackson. And Justice Gorsuch writes that the current border crisis is not a COVID crisis. Remember that this Title 42 authority is public health authority. He says, Justice Gorsuch continues and says, courts should not be in the business of perpetuating administrative edicts designed for one emergency only because elected officials have failed to address a different emergency. We are a court of law, not policymakers of last resort. And let's have a clip here. We have Arizona Attorney General Mark Brnovich explaining on Fox this morning why he agrees with the majority and not with Justice Gorsuch.
With all due respect to Justice Gorsuch, I think the majority got it right because Arizona led the coalition to try to stop the Biden administration from rescinding Title 42. And in a nutshell, here's why. What's good for the goose is good for the gander. And for years, the left has sued President Trump and they sued President Bush before then over procedural ways that the federal government operated. And what the states have essentially argued is when the federal government won't do its job, when it won't defend the law, the states have a right to come in and intervene. And in this instance, we know the Joe Biden administration has completely incentivized and decriminalized people breaking the law. So if Joe Biden won't enforce the law, we need to do everything we can as states to protect our people. And Title 42 is one of the only tools we have left in our toolbox.
Kim, what do you make of this? I get the policy argument that Mark Brnovich is making there, but I'm a little sympathetic to the Justice Gorsuch complaint that the border crisis is not a COVID crisis, at least not anymore.
Yeah, I mean, look, I'm very sympathetic to Arizona and all of the states that are dealing with the fecklessness of the Biden administration and its inability or unwillingness to deal with the border. But Justice Gorsuch made a powerful point in that dissent, which is that he basically said the Supreme Court kind of dodged here in that it decided to take up this issue of whether or not the states have a right to intervene. And as Gorsuch was pointing out, that's really beside the point. Let's say that we decide they do. There's still this issue of the fact that Title 42 is the wrong tool to be using here because it's a made-up tool at this point. Everyone understands that the public health emergency has receded. And by the way, there's also been studies that show too that the notion that this is in any way stopping COVID from spreading in the United States or coming into the United States is quite ridiculous. So it's not just that the emergency is over, but the notion that this particular policy helped in terms of public health was always somewhat nonsense. And, in this regard, it's very hard to see how what the states are doing here, Mr. Brnovich and others, is any different than what Joe Biden did with his eviction moratorium, really in a stretch because he didn't want to throw people out of their houses, suggesting that there was some public health aspect to this, which was simply not true. Or, what he's been doing with his nonstop extensions of emergencies in order to continue to allow recipients of student loans to not have to engage in repayment. It's all a bit of a fiction. It's using a crisis as an excuse, only now the crisis is done. That doesn't mean that there isn't a huge crisis at the border and an emergency. And that was undoubtedly what the majority of the Supreme Court was fundamentally reacting to. But it doesn't make it any better as a matter of law.
So where does this leave President Biden's border policy, Monet? The Supreme Court generally wraps up its annual term at the end of June. And if this case is going to be heard in February, it's possible we'll get a ruling before June. But at best, this buys President Biden 6 months, I think. So, Monet, do you think he sees this as a chance to change his policies, go to Congress and ask for some changes in the law to deal with this border crisis? And what would that look like?
Yeah, you would imagine that he does. Just to reiterate, the Supreme Court order on Tuesday did not mandate that the federal government continue to enforce Title 42. It merely said that they're allowed to do so. And the White House very quickly took that opportunity to say, we're going to keep enforcing it for the time being, even though they had been saying very recently that they were ready to cancel the policy. So they clearly have been watching the activity at the border. They know how many people are crossing now and are preparing to cross if the policy is lifted. And they said, wow, this is going to really buy us some extra time to see if we can prepare a better border defense. In recent weeks, the Department of Homeland Security has basically pitched a piecemeal of policies to continue enforcing the border in the absence of Title 42. But everyone knows that those policies really won't amount to anything nearly as effective as being able to expel a lot of migrants before they can even could claim asylum and get the chance to remain in the country indefinitely as they await their hearings. So it seems as if the president realizes we have to come up with something stronger. There have recently been proposals in Congress to basically give legal authorization from the legislature continue to enforce a Title 42-like policy that might have a lot more legal strength than just the president deciding to continue a COVID emergency indefinitely. So that's one avenue. That attempt to get a legislative solution failed before. There wasn't enough political will on either the far right or far left to implement something like that. But if Biden steps in and really tells Democrats, this is something that we need and something I really want, it's possible that they might be able to muster the political will. So what the form of the solution is going to be is still up in the air, but it stands to reason that the administration knows we've just been gifted a few more months to come up with something, and they'll be trying to see if they can get some congressional agreement.
One final thought here on this question is what the Supreme Court's intervention here looks like. There has been a lot of criticism of the so-called shadow docket. Justice Samuel Alito, pushed back against that in a speech recently, saying it was the emergency docket and nothing more. But the Supreme Court has the authority, if it wants to, weigh in on this question about whether the states can intervene to summarily reverse what the lower courts did. And it seems to me, Kim, that some of the criticism of the emergency docket seems to have changed the way the court is operating. It's not weighing in here immediately. It's setting this case on its argument calendar for February. And I mean, I suppose there are pros and cons of that. The pro would be that you get a real hearing on the question that is before the court. The con is that it puts delay into the system. Instead of having an emergency order on the emergency docket to take care of this question, whatever the majority of the court thinks, we're going to have a 6-month delay here. And in this case, it is redounding to the benefit of states like Arizona. But if this is the way that the court is going to operate in the future, I mean, it could be the eviction moratorium or something next that gets a 6-month lease on life because the Supreme Court is reluctant to wade in without an oral argument.
Yeah, I think we'll have to wait and see. Look, the emergency complaints were always overblown. Alito was right to push back on them. One of the things that has changed that the critics never acknowledge is that, we have administrations now that are routinely abusing their authority and doing so in ways that stack up these deadlines and almost makes it incumbent upon the court to intervene, lest a policy that is in fact entirely lawless become an immediate reality. So there has been a couple of times where the court really has had to step up to the emergency plate, not because it was exceeding its authority, but because the Biden White House was. We'll see if this particular decision to put this on the regular calendar means a change in how they approach this. You could make a call in this particular case that waiting and providing the Biden administration some more time to get something in order was certainly reasonable, and therefore this didn't count as an emergency. I'm not necessarily sure this signals an entirely different approach from the court, but it is a good question and something to watch.